glib, defiant, contemptuous, and disrespectful. Respondents entertained a subordinate employee at his beach home. There, they took shots of whiskey and had beers.
He admits to touching the inside of her thigh without consent.
I'm not looking at my hand, and I pat it. I suspect it was the inner thigh by the way she was sitting, so that it's clear she's wearing dungarees.
Next, we'll hear from, in the matter of R. Douglas Hoffman, Judge of the Municipal Court. And you'll have the opportunity to speak after Mr. Ramsey. The last word goes to respondent.
Thank you. Let me begin by repeating some of the key words that the Advisory Committee on Judicial Conduct used to describe R. Douglas Hoffman. Glib, defiant, contemptuous, and disrespectful. And that was after hearing respondent's own testimony during the 2023 hearing on charges that he violated the Code of Judicial Conduct. Ultimately, after considering all the evidence before it, the ACJC found that respondent violated canons 1, 2, and 5 by clear and convincing evidence and recommended removal. This case isn't complicated, and that's in part because respondent has asserted he accepts the findings of fact and misconduct in the ACJC's presentment. And what are those findings exactly? That on October 15th, 2022, respondents entertained a subordinate employee at his beach home. There, they took shots of whiskey and had beers, and then after hours of drinking, respondent touched his guest in a sexually suggestive manner and without consent. The ACJC found that both the liberal drinking, along with the unwanted, inappropriate touching of his guest's knee and inner thigh constituted ethical breaches. They also found respondent's demeanor when testifying to be flippant, betraying a palpable disrespect for the disciplinary process, and that he exhibited a lack of self-control, probity, and sound judgment on the day of the incident. Respondent had every advantage in the situation he created on October 15th. He's much older with far more life experience than his guest, but more than that, he was her boss and a judge, a position that automatically engenders respect and trust. And while respondent maintains that he was unaffected by the alcohol he drank that afternoon, his guest was intoxicated. Since then, he's attempted to minimize and rationalize his behavior. During his appearance before the ACJC, he defended supplying his guest with so much alcohol by saying he assumed she, quote, learned how to drink in college, end quote. Later, when asked whether he sought permission to touch his guest, he was incredulous that he would even need to ask for consent before touching someone else's body, reflecting a sense of entitlement and a failure to appreciate the problem with his behavior. Following the presentment's recommendation, this court filed an order to show cause and complaint. Because respondent did not contest the salient facts or code violations, and said he would only be challenging the quantum of discipline to be imposed, he waived a right to a hearing. Yet, he continues to vehemently deny that the touching was improper and unwelcome. As social values evolve, the kind of conduct that affects the public's confidence in the judiciary changes. In turn, the legal standard changes. And when we apply that adjusted standard to the totality of the circumstances here, respondent's conduct throughout the day, along with his refusal to fully acknowledge its impropriety, it warrants removal from the bench. Lesser discipline is insufficient to ensure that the judiciary and the public is protected from a judge who doesn't respect interpersonal or professional boundaries and shows disdain for the rules governing his esteemed profession. The people of New Jersey deserve better, as does the judiciary.
Questions, anyone? Anything else you'd like to present? Mr. Ransom.
Thank you, Your Honor. I'm just wondering how my client or any other sitting judge would know what these amorphous, evolving societal standards are, and that he or she would be subject to them, okay? That years of precedent that this court has come up with over the years to guide us in these disciplinary cases would be ignored. I should have known something was up when the ACJC opinion didn't mention any of them, save for the Seaman and the Bryan cases, notwithstanding the fact that I had cited them all in my brief. The most egregious of all of them was In re Jones, where this Superior Court judge at a Christmas party got drunk and was groping all kinds of people there. I think there were 6 victims, 5 of whom were employees of the judiciary, one of whom was a private citizen, a bartender there. And the court took all that into consideration and suspended this individual for 4 months. And I have to tell you, by this court's standards, excuse me, 4 months is a long period of time. Typically, the suspensions of judges in Superior Court, they range 1 month, 2 months, because judges can't have any other income outside of their judicial salary, and the court doesn't want to starve them to death. I mentioned to you a moment ago, I teach this stuff to judges and lawyers. I'm the author of the principal text on judicial discipline in the state. And I ride around thinking about the case. I thought to myself, what about the cases where there have been removals of judges, from the municipal court bench or Superior Court bench? How do they stack up against the conduct in this particular case? And, I thought about it, and these are cases to me that just right off the top of my head, they kind of rank up there in the pantheon of judicial disgrace. Boland, municipal court judge who exchanged sexual favors in exchange for favorable rulings in municipal court. And finally, In re Sasso, case involving a judge again who was unbelievably arrogant, nasty, rude, and just completely tormented the people who came before him, many times appearing on the bench while intoxicated. These are the cases that merited removal from office. These are the ones where the court said, no, this is intolerable. The people of our state have a right to expect better. Now, what do we have in my client's case? There's plenty of ammunition here to discipline him, and I agree with the Attorney General. Everything she said, with one exception, is completely justified, true, and admitted by the respondent. He has to be subject to some level of discipline. This train that was going off the tracks should have been stopped at any number of times by stopping, letting her drink and get to the point where she was so unbelievably intoxicated that she was falling down drunk, allowing her to engage in conversations with him that were completely inappropriate, especially between a subordinate and her judge. The whole thing was just a complete catastrophe from beginning to end. On the other hand, my client has adamantly maintained and maintains to this day that he did not touch her in the way that was described. The closest he came to that was, and I think the ACJC made this finding, that he put his hand on her knee trying to comfort her when she was talking about something of a highly personal nature, sexual in nature, and was becoming upset by it.
Mr. Ramsey, we understand that the facts are undisputed.
They are.
So what is it that your client admits happened?
Your Honor, I will tell you, my client, again.
Let me finish the question. Happened in terms of touching. What is it that he admits?
I'm sorry, Your Honor.
What is it that your client admits in terms of the touching aspect?
Hand on her knee to comfort her because she was getting very upset about something that she was talking about. And so he denies. And this is what this court would have to find de novo beyond a reasonable doubt, is that he slid his hand up onto her thigh. Okay. And that's really what the whole case comes down to.
Sorry. So he denies, I think I might have misunderstood. He denies that he touched any part of her body aside from her knee.
Not true, Your Honor.
Okay.
He admits that he put his hand on her knee, and that was actually comforting to her.
Yes.
Okay. It was the move from her knee moving up her leg.
I just stated he denies that he touched any part of the victim's body aside from her knee.
Correct.
And you said no.
I'm sorry, Your Honor, but maybe I misunderstood your question.
Okay, so he admits that he touched her knee, but only her knee. So the inner thigh, he rejects altogether.
Correct. And he maintained that before the ACJC. So
this is the Q&A in front of, with counsel for the ACJC. And the second part, what part of her body did you touch? Same thing, my right hand to her leg. It wasn't her knee, it was her leg. The thigh? Yes. Was it the side of the thigh, the front of her thigh, the inside of her thigh? Be more specific. The way she was sitting, it would be the inside, because you got to remember, I'm sitting like this.
Mm-hmm.
He admits to touching the inside of her thigh without consent.
Well,
do you dispute that?
Again, I'm not so sure that that's what he meant by his testimony.
That's what he said, and he has said to us in waiving the hearing that he is not challenging the facts
Mhm.
and the finding of facts in the ACJC's presentment. And the ACJC certainly found that he touched the inner thigh of a subordinate while drunk or being drunk without consent. So I understood that was not up for discussion today. You have a different position. You may
It's only for discussion to the extent that Your Honor would have, and the other members of this honorable court would have to find that beyond a reasonable doubt at this point.
Which you've asked we not do, but have conceded there is enough for that finding to be made. Is that accurate?
It's going to have to be. We've stipulated to it.
Fine. So there is no dispute then that he touched her inner thigh.
Correct. Well, as per what the findings of fact are, yes, you're going to have to go with that. We admitted to it. Okay.
Let's go with that then.
All right.
Please proceed.
Let us assume, arguendo, that that's exactly what happened. Okay. So then the question is, what is the level of discipline that's fair and appropriate in this case? And I'm suggesting to all of you, based on years of precedent involving improper touching, which I've outlined in great detail in my brief, and contrasted with some of the cases I've just mentioned to you where people were removed from office for egregious conduct, this comes nowhere near close to meriting removal from office. It's just not a removal case. This is something that was done momentarily in private. And none of that excuses it. Again, there has to be discipline in this case. It's just not a removal case.
In private with a subordinate who works for.
I'm sorry, Your Honor.
In private with a subordinate who worked for the court.
Correct.
Where he was the judge.
100% correct.
Is that entirely private?
Well, it's private in the sense that the public's not exposed to any of it. It was just between the two of them. That's what I mean by that.
This isn't a question of your fine advocacy.
I'm sorry, Your Honor.
This is not a question of your fine advocacy. And I understand fully why you would look back in time to precedents to argue, including from dated cases that were decided 20, 30 years ago. We rely on your book as well and cite it throughout the state.
That's nothing to be proud of, Your Honor.
And have it. So this is not about collecting past matters. The question is, how do we deal with change? Is it time now to deliver a similar notice to all judges that conduct of the type that we have here, of the facts that are not in dispute, that a judge touched without consent in an intimate area while having provided alcohol to the individual who was then drunk, a subordinate, that has no place in the judicial system.
It doesn't.
And that a judge should not, and I put this to you, should not expect to be able to come back after 120 or 240 days and continue to serve on the bench.
But Your Honor, how is that fair, though, to the respondent here, who would have no way of anticipating that? And when I think about how the lives of these two young women were ruined and sabotaged for no reason at all because of the sexual perversion of these two judges in Seaman and O'Brien, and how their lives were ruined, how what should have been the happiest time of their professional lives was turned into the worst time of their professional lives. I'm not quite sure what the court had in mind back in 1993, for example, when the O'Brien case came.
So Seaman was 1993, and I think the facts of Seaman are important for this very conversation. Mm-hmm. There we had a judge sexually harass a female law clerk over the period of several months, suggested having sex on his desk, attempted to put the clerk's hand on his private parts, improperly touched her under her skirt, and got a 60-day suspension.
Correct.
Is it within the remote realm of possibility that would be meted out as the appropriate outcome today? Mm-hmm. And would it be unfair? Could one suggest that no judge could have anticipated that the suspension or removal, the suspension would be far greater, or there might be even more serious consequences if that were being heard 31 years later today?
You're posing a very tough question to me, Your Honor. I think that today, if these cases came before this court, they would likely be removal cases, because it's really outrageous conduct. I'm not quite sure what the court had in mind all those years ago, but it is what it is. But I can't be concerned about general public policy. I'm concerned about my client And it's just a matter of fairness. If the court wants to sort of chart new territory and come up with a new rule of law and put everybody on notice this is what it's going to be in the future, that's perfectly fine.
And what's the penalty for your client under those circumstances?
I'm sorry, Your Honor.
And what would your recommendation be for the outcome for your client then?
I thought it should be a censure case, but again, it wouldn't be unreasonable to suspend him for a short period of time either. And, do a written opinion saying this is the last. Anybody who does this in the future can expect removal. All right. But it's really just a question of fundamental fairness.
Mr. Ramsey, do you really contend that your client was not on notice that there would be very serious consequences for the conduct?
I don't even think he thought about it. I really don't. But if he's going to speak to you in a moment, maybe he's probably the best one to answer that question.
We're talking about a judge and someone obviously who's had a lot of experience in the law. Are you really telling us that he would not have been on notice that conduct would have very serious consequences when this was admittedly, because we're dealing with a stipulated set of facts, this was done?
Your Honor, I can't speak for him. Okay. All I can tell you is, what the objective facts are and my advocacy along those lines. I have to tell you, in all honesty, he's universally respected as a wonderful jurist, loved equally by prosecutors, defense attorney, and the general public. He's just an excellent judge and has been for a long, long time. This highly publicized case did not deter the municipalities that employ him from keeping him on. He's been sitting on the bench continuously during all this time.
Then we'll hear from Judge
Hoffman. You get the last word today. Come up here and say hello to everybody. Thank you, Your Honor.
Thank you, Mr. Ramsey.
Good afternoon. Thank you for taking the time to hear the case. Let me let you know a little bit about me, which may or may not assist you in making whatever decisions you're going to make. I've been married twice. First time, 17 years. Second time, 37 years and still going. I have 6 kids, 4 of which are daughters. I have never had an ethics complaint filed against me that was found for any reason at all in the 52 years that I've been practicing law. I was a little taken aback when they said I was relying on the transcript. I am relying on what the hearing was. I am not stipulating, and I think I put that when we were going, voting the order to show cause coming to the Supreme Court, that and this may be semantics, touched her leg. What I did was, a little background on that. She texts me out of the blue, says, "What are you doing?" Sitting on my front porch. She shows up, sits on my front porch with me for about an hour. She then says, "Are we going to have anything to drink?" I then said, "I'd like to show you the house." I show her the house. We then come back and she said, "What are we going to drink?" I have a cabinet. I opened the cabinet. I said, "What do you want?" So she picked out a liquor. She also said she wanted, I can't tell you at this point whether it was a beer or a claw or whatever it is that my kids drink, out of the refrigerator. We're sitting in the living room, which is like a fishbowl. There's windows all around, the door's open. My son's girlfriend is coming in and out of the house with her daughter because she was shopping. My son is replacing a window in the back part of the house, which is like 2 rooms away. I poured the first shot and I opened the refrigerator door and said, "Take what you want." The second, third, and fourth shot, I know exactly how many there were poured by her. And she said, "Get out here and let's have a shot." That's what happened. As far as her knee, I did. I patted her knee, which she said at the hearing was consoling. She then started crying again, and I'm sitting in my chair. She's turning sideways. I'm not looking at my hand, and I patted. I suspect it was the inner thigh by the way she was sitting. I didn't rub her leg. I patted her leg to console her because she was crying about something with her boyfriend that doesn't really matter to this court. So I did the knee, patted the, which I guess was the inner thigh, twice, and that was it. I have always denied that I was rubbing her leg. I had no intention of rubbing her leg. I had intentions of consoling her. And just so that it's clear, she's wearing dungarees. That's it. I mean, yeah. It's almost like, when did you stop beating your wife? I mean, I didn't do anything. If I was deemed to be flippant at the other hearing, it's because I was asked a question by Mr. Ramsey and I hesitated answering as to whether I thought it was a violation of the canon to have her there drinking. I've since found out that absolutely it's a violation of the canon and everything else. I don't look at anybody as a subordinate because, number one, I don't really hire them. They get my blessing. My court administrator hires them. They're just people that I know, that I deal with on a daily, weekly, whatever the court schedule is basis. So wasn't looking for a power play. I wasn't looking to do anything of a sexual nature. Again, I got 4 daughters, and I wasn't looking to get her drunk. I mean, I'm drinking. I'm called into the kitchen 3 times by her, and I went. I have no idea. I have never been out with this girl other than one Christmas party that I would do for the employees of Robbinsville. I don't know her capacity. I don't know whether she was drunk. And I've said in the transcripts that I've gone through that she did not appear to me to be drunk. She was not slurring. She was going from here to maybe the corner of that table, which is where the door was, and disappeared. So I'm not watching her walk. I'm not watching her stagger. I'm not watching her fall. I didn't see any of that. And I had no idea until I was told afterwards that she was drunk. If you have any questions, feel free.
When she showed up, were you startled?
No. She texted me. She said, I'm coming to the island. Can I stop by for a visit? And I said, sure. And my shore mentality, which I've turned off, says if somebody comes, you have a house at the shore, you entertain them, you say, yeah, you want to stop by, feel free. And she was there 4 or 5 hours. The first hour was sitting on the front porch.
Did the ACJC find in its presentment that you touched her inner thigh without consent?
I had problems with the wording, because I know at one point it said if you have the order to show cause, then you can have a separate hearing and contest the facts. I'm not contesting what they found. I am contesting that it was a pat as opposed to a rub. I mean, they're saying that it went from her knee up, wherever. I didn't do that.
Did they make that finding?
Did they? No.
What did they find with respect to the second touch?
That the finding that I read in the decision was that I was rubbing her inner thigh. And did I pat her inner thigh? Yes.
And you're disputing their finding that you rubbed her inner thigh?
Absolutely.
My understanding from letters leading up to this, when you waived the hearing that the court had set in motion before another panel, was that you were not to dispute, you were not challenging the findings of fact and misconduct contained in the presentment.
If you read the letter setting this up for the court, it was very specific, and I told Mr. Ramsey to be very specific, that I am not admitting that I rubbed her leg. I am admitting that I patted her leg twice. And I clarified it in the letter because he said we accept the findings of the lower thing. I didn't accept that finding because it didn't happen.
Did you agree not to object to the court's ability to find, beyond a reasonable doubt, that there is cause for removal on the basis of the existing record?
I agreed to have a hearing in front of the court so that point could be clarified. I did not agree that I was rubbing her thigh. That's in my head.
You agreed that you patted her inner thigh.
Absolutely. 2 pats and done. And that was more of a consoling nature than anything else because she's crying on my couch, complaining about her boyfriend. And that was after the knee. It didn't go from the knee to the thigh. Couple pats on the knee, couple pats on the thigh, and that was it.
I don't have the letter in front of me right now, but I do recall, and we will go back to the premise for the court agreeing not to conduct an additional hearing that it had set in motion. My recollection was that although you disagreed that there was proof beyond a reasonable doubt. You did not disagree that there was a basis for the court to make such a finding with respect to the misconduct found by the ACJC.
If I were to agree that there is a basis under a presumption doctrine, that doesn't mean that I agree that all the facts were correct.
If the letter says what my recollection is, and it could be faulty, are we beyond that?
I know what the letter should have said, and I know what I believe the letter did say. Whether I got a copy of it or not, I don't know. But if I did not, I was very careful when I was dealing with Mr. Ramsey as far as what I would consent to or not. The hearing was fine. I mean, we went through investigators, we went through a hearing, everybody testified. But if you look at the language that should have been in there, Mr. Ramsey's letter, I believe I made a distinction.
Here's what the letter says, and you're copied on this letter, dated July 25th, 2024. Respondent acknowledges, and for the purpose of this proceeding, will not challenge the findings of fact and misconduct contained in the ACJC's presentment.
That's not my understanding what the letter was, but if that's what the letter was, that's what the letter was.
And the finding, I'm looking at page 13, one of the findings of the presentment is that, referencing the extended summary contained, these circumstances, respondents drinking alcohol liberally with LW and touching her inappropriately, the latter without her consent and in a manner that may reasonably be construed as sexual in nature, coupled with respondents' attempts during these proceedings to portray LW's offense at misconduct as the perception of a muddled mind, ... These are the findings of the ACJC that you did not challenge.
I must have misread the letter. And I guess I'm stuck with, what we have here today, but that doesn't mean that I'm not denying that I touched her thigh. I'm saying I patted her thigh after I patted her knee. Now, I don't know. I didn't look down to see where I was patting. She's sitting next to me, facing me. Her left leg is cocked. And that's when I went to pat. That was where I went to pat.
Please go ahead.
That was it. I just wanted to clarify that.
Thank you.
Thank you.
Thank you, Your Honor.
Thank you to everyone. We will take the matter under advisement.
Judge, to call the next matter, it would be in the matter of Mr. Hoffman, represented by Mr. Ramsey, with Rachel Weeks from the Office of Attorney Ethics.
Thank you, Your Honor. This matter comes before the board as a disciplinary stipulation following Respondent R. Douglas Hoffman's removal from the municipal court bench. Respondent has stipulated that he violated RPC 8.4G by engaging in conduct involving sexual harassment of a subordinate employee. The Advisory Committee on Judicial Conduct filed a complaint, and after a hearing, the Supreme Court found respondent violated multiple judicial canons and ordered his removal from office. Recent precedent supports the OEE's recommendation for discipline in the range of a censure to a short-term suspension. Accordingly, the baseline quantum of discipline here is a censure. The court found respondent's demeanor during the hearing to be flippant and disrespectful, but here he's been cooperative. He stipulated to the facts and his violation of the rules of professional conduct. The OEE submits that respondent's demeanor during these two separate proceedings balance each other out.
Which, by the way, in reading all these precedents, I represented most of these guys, so I'm kind of like an expert on 8.4G, and which is nothing to be proud of, I might add. Typically, Supreme Court tries to not suspend respondents for that long a period, 60 days normally being the longest, when they're dealing with Superior Court judges, because they don't want to starve them to death, because they can't be engaged in any other type of activity that will yield an income to them. That's not the case with municipal court judges, so all bets are off in terms of how long they get suspended. I brought this up before the Supreme Court, and the Hoffman case really was used by the court to announce a new rule of law, saying that we're in a new era, a new age, with new expectations of society generally, and what we expect of judges in particular. And we are not going to tolerate 8.4G violations any longer. And I'm suggesting to this board that a censure is the appropriate level of discipline in respondent's case. There's one thing I'd like you to keep in mind, and please look at it from my perspective, because I'm a teacher. I teach this stuff all the time to judges and to attorneys. And I'm always a little, I'm trying to think of the right word here, not offended, but kind of taken aback when I hear people who should know better refer to attorney discipline as punishment. Punishment, all right? And I always have to say, hey, time out, all right? You have to understand that when we're talking about attorney discipline, nobody is getting punished. It has nothing to do with punishment. Punishment is strictly and solely within the province of the New Jersey criminal justice system. This is not about punishment. So get that out of your lexicon, okay? It's not about punishment. The goal here is to protect the public and preserve public confidence in the bench and bar. That's what this is about, okay? It's not about anything else other than that. The aggravating factors, they are what they are. The mitigating factors are, as I've just laid out, plus the fact that he has preserved resources from the Office of Attorney Ethics by stipulating to this outcome. And I would urge the board to please take everything I've said into consideration and recommend that you impose a censure in this case. That should be sufficient discipline to accomplish your mission. And I thank your Honor and the board for your attention to this matter. And again, I thank my adversary.
Mr. Ramsey, is your client practicing law currently?
No, he's not because of illness, but he's hopeful to recover sufficiently. He's been sick now for the last 6 months, but his hope is he'll be able to recover at some point and engage in practice. His main real estate practice for the future would be real estate.
Any other questions? No, then thank you. We'll take this matter.
Your Honor, I miss you in the appellate division. I wish you were there again.
It's been a long time, Mr. Ramsey.
I know. A long time before you're back, too. I'm going to wait for the Supreme Court to grab you to sit there when they're short of a justice.
Did that for 4 years. Okay. Thank you so much.
Thank you, everybody. Thank you, board.